The third case on this morning's docket is case number 107906, State of Kansas v. Dominic Verser.
Good morning. I'm Rick Kittle. I represent Mr. Verser, and I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
I'm in a bit of a quandary here because when I came into court this morning, I intended to talk about the first issue of the yellow brief. But after hearing the previous arguments, I also have this same issue in this case, and I'm not sure what to talk about first in the time that I have. So I guess at the risk of getting an answer, I would ask the court if there's any particular issue that they would like to hear about first in the time that I have.
I'd like to hear your take on the jury questions issue first.
Okay. The controlling law, as I understand it, says that it's a critical stage of the trial when the court communicates with the jury. I'm interpreting that language, communication, as being a transfer of information. And in the situation where a written note is delivered to the jury in the jury room, that transfer of information only takes place when the jury actually reads the note. And of course, when that happens, it happens outside the presence of the judge, the defendant, the public, counsel, all of the main people involved. And I think that's why there is a violation of the statutory law and the way that the statutory law has been interpreted by this court. There is a case called State v. Mance, which I think is cited in the yellow brief, and it basically it's an old case. Judge Elliott would have called it hoary with age, but I think it's still good law. It says that the defendant doesn't have any constitutional rights attendant to being present when the court discusses instructions with counsel. So if a proceeding between court and counsel to which the defendant has no attendant constitutional rights, how can that satisfy the defendant's constitutional right to be present between a conference between court and jury, to which the defendant does have an attendant constitutional right? The other thing I want to mention is State v. King. King, I think, came down in August of last year, and I had an argument before the Court of Appeals the week following the issuance of King, and it had this issue in it, and I think it was Judge Lieben that basically said, Mr. Kittle, you finally won this issue. But of course, I've never got relief for any of my clients in the many cases that I've raised this issue, so I've never won it. But what was remarkable to me is that the Court of Appeals looked at King as kind of a new statement of the law, but it's not. King stands for the proposition that a defendant has a constitutional right to be present at a critical stage of the trial, and any time the jury, during deliberation, asks a question about the law or the facts, the jury must be brought into open court to have the response to its question given to it in the defendant's presence, unless the defendant voluntarily absents himself. That principle of law has existed for decades. McGinnis says it from 1998. There's an older case than that, State v. Crease, that says it. So it's not a new statement of law. The fact of the matter is that district courts have either chosen to ignore this principle of law, the statutory law, or they haven't been aware of it. Because in the vast majority of cases that I've looked at over 25 years, when there is a jury question asked during deliberation, it's handled with a note delivered to the jury in the jury room. And as for structural error, I guess what I'm trying to do is step back and look at this. How would I, as a litigant, appreciate what happened in the jury room, or what happened in court in these situations? What litigant would want to be tried at a proceeding where a critical stage of the trial took place in the complete absence of the public, the defendant, the counsel, and the court? I would argue that it's a corruption of the trial process.
But easily resolved, simply objecting and requesting that the jury be brought in. to open court?
Well, the way I read the statute, it says that unless the defendant is voluntarily absent. I'm looking at that as being a personal right to the defendant.
Whether it's
And
personal,
in-
excuse me,
I'm
Mr.
sorry.
Kittle, but whether it's personal to him or not, whether it's something counsel can handle, why doesn't Justice Johnson's solution work?
Well, I guess because in most of the situations I see, this is just done as pro forma. You know, this is the way we've handled things, and the court never asks counsel if there's any objection. The court never advises the defendant of the rights he has to public trial, to have the judge present, to be present during the passage of information.
In your case, the judge did ask.
He did.
So this one
And so, you know,
deviates from the
I
norm.
recognize that's a worst case for me, but I'm looking at, you know, I've raised this in dozens of cases, and it seems clear that for decades there's just been a violation of the statutory law and the law that this court set down interpreting that statutory law. And I don't know what the justification of it is, other than it seems more convenient to do it that way.
Are you aware if this is a common practice in other jurisdictions? Because I think, I don't remember who said it, but there really doesn't seem to be any case law on, at least on the public trial aspects of it in any other jurisdiction. And I wonder, are they just all doing it differently, or is this issue just never coming up with
well-
respect to this particular practice?
Are you talking about the practice of using a note?
Using a note,
Okay.
right?
Yeah,
Because
it's
it is
common.
common.
It's common
It is
across the
common.
state.
Yeah, it is common.
At least that's my experience. And
But
you
I
know,
just
our
wonder
office gets cases from every jurisdiction.
I don't think you were successful in finding any case law outside of Kansas either, so.
No, that's true. I mean, I've read cases that have said, well, this is problematic because, well, first of all, there is no record being made. And I think it's putting the defense in a very difficult position to say what's the real problem here when there's never a record being made if you use this procedure. But you know, the possibility exists that if a bailiff or whoever, some courier delivers a note to the jury in the jury room, the jury may read it while the bailiff is still there and make comments, which would constitute deliberations taking place in the presence of someone who's not on the jury. You know, if it could be as simple as, you know, most of these are handwritten notes by a judge. Suppose it's given to a juror and the presiding juror says, I can't read this, and gives it to the bailiff and says, what does this say? Well, that's the bailiff interpreting what the judge supposedly said. And I would argue acting as part of deliberations in that case. So there are problems that can exist. And yes, you know, they're not necessarily made known because we simply don't have a record of what happened.
And the reason we don't have a record is because you didn't ask for one. I mean, you didn't look into it.
Well, that's true. Nobody asks. I mean, that's been the practice. I would argue that they shouldn't have to ask because the obligation is on the court to do things the right way, bring the jury into open court. You know, what's the purpose of King? What's the purpose of Coyote? What's the purpose of McGinnis? To bring the jury in so everybody is present, everybody knows what's going on, and we can make a record of the proceeding. And when that doesn't happen, I would argue it's kind of unfair to ask the defendant to prove that there's been some sort of prejudicial error when we don't have a record. And the reason we don't have a record is because the judge isn't abiding by the applicable law.
Well, if McGinnis and Coyote and other cases are so clear and you've been relying on them to support your position today, how is it that you apparently are the only lawyer who's raised this issue? Going back to the issue of why wasn't there contemporaneous objection by the lawyers who have available to them McGinnis, Coyote, and the others?
I think, well, I can only guess, but I think this is just the common practice. Everybody's taking it as the way things are done. This is the way the court handles these matters. Local counsel that's what they're used to, and that's what's being done.
Is this case a little different than that? Because wasn't there some discussion between both state counsel and defense counsel about whether or not there was this needed to be read to the jury in open court and and counsel said, no, I'm not requesting that? Something to that effect? This is a little bit different because most of the time that dialogue doesn't even take place, but here it did.
I acknowledge that, yes, this is different, but that's, and as I said, that puts me in a little bit different position, maybe a less advantageous position than other cases, but I'm arguing this, maybe not just for this situation, but as a larger question of what's the propriety in this situation.
Right. I understand, but that discussion did take place in this case, and it seems to me that there was no, in fact, when it was brought to the attention, there was an affirmative response, no, I'm
did.
not requesting it.
But the thing I would argue there is, because the statute says, unless the defendant voluntarily absents himself, I would argue it's not good enough for defense counsel to be asked to say, oh, this is okay.
I understand, yeah.
The court needs to advise if the court is going to use this procedure, the court needs to advise the defendant of his right to be present, needs to advise the defendant of his right to a public trial, and ask the defendant, is it okay if a critical stage of the trial occurs outside the presence of the judge? And again, I think that's such a corruption of the trial process to have a trial going on in the absence of the judge that it is a matter of structural error.
Actually, the attorney here probably answered the chief's question when the attorney says, well, I've never heard of doing it that way, bringing the jury in. And so
Well, yeah, that's
it's
true.
just not done, and so counsel don't ask for it because it's just never done.
But the prosecutor apparently raised the issue, is that right?
Yes, I believe
The
that's what happened in
prosecutor
this
said
case.
That it had to be.
The prosecutor was aware that at least there had been some litigation or something to the effect
Perhaps the prosecutor had read McGinnis and Coyote and the other cases.
that could be.
I just looked at the civil statute, which is probably not something you've cited in all of these arguments you've made, but I think maybe it supports your position. Because it says, after the jury is retired for deliberation or request further information as to any part of the law or evidence pertaining to the case by communicating the request in writing through the bailiff to the court. The court, after notice to counsel for the parties, may consider and respond to the jury's request in writing or on the record. So that language is in stark contrast to the language in the criminal procedure statute, isn't it?
It is.
And maybe that's where the practice is carried over.
That could
confusion
very well
between
be.
But
I would argue that there's because we're talking about a criminal trial here and the defendant has certain constitutional rights that aren't going to be at issue in the civil setting, that maybe that's why we have a more stringent view of the law.
it would seem so, and I think we also in construing statutes can compare the two and see there that the legislature obviously used different language. in the
Right. I
criminal
think they're
procedure
aware of the difference and that's reflected in the statutory law.
Quite a circumstance when we have the legislature more aware of something than lawyers. Can I ask you about the mistrial motion real quick?
Sure.
Because you're out of time. How do you get around arguing on appeal that the trial court erred in granting or agreeing with the argument that defense counsel made that the mistrial should have been denied, when the state asked for it?
Okay. At the point that Cox testified, when his testimony was over, I think it was pretty clear to everybody that there was perjury involved. He testified under oath to one thing on direct and said the exact opposite on cross. They both couldn't be true. The court, I think it's clear in statements that the court made. I mean, one of the court statements that the court said is the jury's not going to be able to disregard it after having heard it. The court was clear in its mind that remedial measures were not going to suffice to save the day here. So at that point, and I acknowledge the defense counsel was saying, well, Mr. Verser wants to have his day in court. We want to go on with this. The state was saying, we want mistrial. We can't get a fair trial here. The jury is going to view this us in a bad light because we put on a witness that perjured himself, and that perjury was only revealed on cross-examination.
Isn't that why you don't want the mistrial? You want that perjured testimony or that fabricated testimony to come in weaken the state's case. Here's their key witness, and he's lying.
Well-
Isn't that what you want? I mean, that's why you don't want to
I can understand that argument, but my argument would be that at the point where we know we have perjury, we know there is a fundamental failure of the proceeding, we know that remedial measures are not going to solve the problem, then the court is without any discretion in the matter. This court in State versus Foster said the trial court is under a duty to grant mistrial if there's been a fundamental failure in the proceeding.
What's the fundamental failure?
The fundamental failure in this case is allowing perjury to go to the jury and use that perjury in reaching a verdict.
I think it's unimpeached perjury. Isn't it really, as a practical matter?
I'm not sure I know what unimpeached perjury
Well,
is.
I mean, here, there was obviously some lying going on or some fabrication, but it was exposed. And that's exactly the goal of cross-examination. Every time there's a highly successful cross-examination, the trial has to end in a mistrial?
I think in this case, yes, because, well, U.S. versus Augers is a case I've cited in the brief. It says that a verdict obtained by the use of perjured testimony is a corruption of the truth-seeking process.
Undisclosed perjury.
Right.
That's the question.
Well-
If it's disclosed,
Well, I don't think it makes any difference whether it's
why
disclosed.
doesn't it? I mean, incredible testimony goes to the weight of
Well-
the evidence, not the admissibility. If you're telling a tall tale that no one would believe, you don't say exclude that witness.
Well, here's how I'd
Just
answer.
say you can't give it any weight.
The court, in assessing what was going on here, one of the things the court said is that Mr. Dupree, defense counsel, you worked him over pretty good, and finally somebody, meaning one of the jurors or more than one of the jurors, could say, well, he saw what he saw. We believe what he saw. We believe his testimony, and that's the risk I see to Mr. Verser. And then, when the court made its ruling that it was going to allow the trial to proceed, it specifically instructed the jury. Early on in the trial, Mr. Cox testified. At the conclusion of his testimony, the state moved to have that testimony stricken, and I have denied that motion. So there was an instruction to the jury specifically with respect to Cox's testimony. I would ask the court to put themselves in the place of the jurors here. They've heard Cox testify, one thing on direct, and then on cross he says, well, no, that didn't happen. So the jury at that point was probably wondering, what are we supposed to make of this? It's clear that he's not telling the truth at some point. But when the court specifically instructs the jury, the state, the party that put Cox's testimony on, has asked to have that testimony stricken, and I've said no, I think that had the effect of endorsing Cox's testimony in the eyes of the jury. So if the jury initially thought, well, we don't know what to make of this, we're not going to believe this, the instruction basically tells the jury, well, state wanted to get rid of it, but I'm going to let it go on.
I'm going to let you consider it, and what I'm suggesting is you're only talking about half of it.
I'm sorry, I didn't understand.
What I'm suggesting is that you're only talking about half of it. The other half of it was, I was lying. I was making it up. I mean, there's more to consider there than this part that's inculpatory. There's
Right.
a great deal that's exculpatory to your client. And that's the choice that defense counsel made after consultation with your client, according to the record, that they were going to withdraw their motion for mistrial and hammer away at it. It's
Well-
a rare opportunity for defense counsel to totally obliterate a witness in the way this witness was obliterated.
Sure, I understand. And I guess I would say, well, from the nature of Cox's testimony, we know he was lying at some point. And the jury still was allowed to consider that evidence. So it's possible here, and I think it's quite likely that the jury, and in fact, that was the conclusion that the court reached, that the jury would just conclude that he saw what he saw, and we believe what he saw. I mean, that was the thinking of the judge, who was probably in the best position of anyone to assess what Cox said. And, I think at the point that Cox testified, and the jury reached the decision that remedial measures were not going to suffice here, the court essentially viewed this as having a choice of two things. I can declare mistrial, or I can go forward as if nothing happened. And I would argue at that point the court didn't have two choices. It only had one choice. It had to declare mistrial because it couldn't let the case go forward and let the jury consider perjured testimony. But that's exactly what it did. And not only that, it instructed the jury so as to emphasize and endorse that perjured testimony. And that's what's problematic in this case, and that's why this is not invited error.
See, counsel, you're out of time. Do we have any more questions? Thank you, counsel.
Thank you.
May it please the court, Jennifer Tatum on behalf of the state. Good morning. I'll start with issue 4, just as Mr. Cattell did. We've had a lot of discussion about the generalities, I guess, of this issue before the court this morning, and I have the benefit of going last, so I've gotten to hear a lot of the questions and a lot of the arguments made on it. And I think ultimately the reason that courts are proceeding in this manner and the propriety of that is going to be a question decided by greater legal minds than mine, because I can't answer those questions exactly. But what I would like to do as part of my argument is focus on this case specifically and what happened with regard to this jury in the Verser case. I do believe the statute was complied with, the plain language. Maybe you'll disagree with me, but I believe that the plain language of the statute allows for the jury to request to be escorted to court. I may not be quoting it directly, if they so desire. This jury didn't do that. I also believe this plain language of the statute allows the defendant to voluntarily absent himself from these communications between judge and jury. And I think the record in this case makes it clear this defendant, Mr. Verser, did that.
His counsel did it.
He
Does that
did, but
matter? Your opponent says it matters that it was only counsel who said that's fine. I think
Yes.
that was the extent of it. That's fine.
yes. Well, I think what his counsel said is I've discussed it with my client, and that's fine.
I think he said that about the substance,
Okay.
not about the procedure. And the argument of your opposing counsel is the procedure's wrong, and the judge should be held to a higher standard. Period. That's his argument.
And I respect his argument. I understand what you're saying by that. I don't know that the record's necessarily clear if they talked about the procedure itself or the rights the defendant was giving up. However, there was a discussion in the defendant's presence. That much is clear, that it was possible for him to insist on being present during the stage of the proceedings, and he didn't. And that did take place in his presence. So I would say the record reflects he knew he was entitled to be present during
So
that
when his
exchange.
counsel said it was fine, he was standing right there. That's your point.
Yes.
Okay, thank you.
But if you find that the procedure in this specific case was in error, I would argue that it was harmless under these circumstances. No one's arguing the court didn't give a correct answer. Basically, what the jurors were asking in this case was for some interviews, either written or audio, that weren't introduced in evidence. That's what they wanted, and the court said no. The written note, I think, that the court provided to the jury is part of the record, so I don't think there's any argument to be made that the written note was distorted in any way. I understand the argument about the bailiff. We don't know if the bailiff said anything back in the jury room or not, but I don't think we can decide this case based on hypotheticals. I think we have to decide it based on the record. And there's no reason to believe that this information was improperly communicated to the jury or that it was skewed in any way. Because what the jury is asking for simply was not in evidence. So the bailiff wouldn't have known that information to tell them anyway. So I would argue that the defense claim on this error fails. I'll move now to the mistrial issue.
Before you move on, do you have a comment about the difference between the civil statute? Because we often say the legislature has demonstrated it knows how to say something explicitly, and when they do explicitly state it in another statute, we're loath to say, well, we interpret this to mean the same thing, because if they wanted to say that, they could. And here they didn't say either receive or return in writing.
I think Justice Luker makes a good point. Going back to the civil statute, that's obviously something that hasn't occurred to any of the attorneys up to this point. But I would agree that the writing, the way that the two statutes are written, is meaningful. But I, again, have to go back to specifically the result for this case that I'm arguing in front of you today. I believe the statute was complied with. And I believe if it wasn't, the error was harmless, and it should not be reversed. Moving on to the issue of the mistrial, I agree with Justice Breyer when she said you're only talking about half of this issue. That when the information went back to the jury, they had all of Mr. Cox's testimony in front of them, including he said he was 45% sure. We have to remember that too. Like if he perjured himself, he was a bad perjured witness because he wasn't certain about anything. He said, I'm 45% sure this was Mr. Verser. But they also had him basically crumbling on the stand and admitting he lied. I mean, there's many attorneys are blessed enough to go throughout their careers without having a moment like this in the courtroom.
Well, this is a little unusual. You lost at trial on the mistrial motion, but then defense raises the issue. So we've got a little unusual circumstance.
It's unusual, and I'm sure you're asking yourself, how is she going to stand up here today and say that mistrial shouldn't have been granted when she asked for it when it happened? But I have a good answer for you, I think.
Okay.
And here's what it is. Again, Mr. Kittle's only bringing up half the information. What you have to understand is less than half of this trial had occurred when Michael Cox testified. He was within the first couple days of testimony. He was certainly the first what I would consider a meaningful, like, eyewitness to testify in the case. He was put on first. None of the other essential witnesses, including Kevin Barker, Claudette Barker, Antonio Barker, the firearms evidence, the testimony about the defendant's flight, the neighbor's testimony, none of that had been presented prior to Mr. Cox. So at the time this happened, we did not have the benefit of reflection, long periods of reflection, weeks, months, days. It was hours, basically, or minutes. And the judge took a break, did the best he could, came back and said, I will grant you this mistrial to the defendant if you want it. But if you don't want it, as a matter of fairness, we're going to make the state proceed so they don't get an advantage. And I think even at the time, Mr. Dupree said, and this was his view of witnesses, but witnesses lie on the stand all the time. In this case, he just admitted it. It's not as big a deal as we're making it. But as the trial proceeds on and you reflect on the testimony given by these other witnesses, you realize the evidence is really overwhelming as it comes from the other witnesses. I mean, you have Kevin Barker testifying that he sees the defendant come over to this house following the shooting, blood on his face, looking at himself in the mirror, saying it's all bad. The defendant's mother coming over and handing him an object wrapped in a shirt that he thinks feels like a gun that he's seen this defendant with in the past, and tells him there's an accident, and he's hiding that. The defendant then makes a phone call and disappears from the house out the back door, not to be found for 6 months. You have testimony that came out from the defendant's own mother, Ms. Barker, who pled guilty to aiding a felon, that her son was the one that alerted her to the fact that Olivia had been shot down the street, which is why she made the 911 call. You had testimony that came in from Antonio Barker, the brother of the defendant, who said his brother walked in and told him, I shot Olivia. You had testimony that Olivia was shot with a .223 round, and that inside the defendant's house there was a live .223 round, and on his dresser there was a manual for a Kel-Tec pistol that fired those rounds. You have the testimony from the bullet hole owner who says, I sold a .223 or Kel-Tec pistol that fires these rounds to Tommy Verser, the father of the defendant. And of course, Dominic Verser's seen with that. You have the testimony of the neighbors that put Dominic Verser in the car with Olivia immediately prior to this happening. They describe hearing what sounds like an argument and hearing Olivia screaming. When you have all of this testimony, you have the blood spatter evidence too, which I think was meaningful in the case. You have all of this that comes out, and you have their relationship of the parties as well. Their argument over their daughter, the fact that they were fighting in the weeks prior to her murder. All of this comes out after Mr. Cox testifies. And surely, when the judge considers all that evidence in the light of Mr. Cox's testimony, surely that's meaningful to him. And that's why I can stand here today and tell you, at the time I asked for mistrial, not all of the information was available.
And you didn't renew that motion later after all this evidence came in? I don't remember.
I didn't renew the motion for a mistrial. I did renew the motion to have the testimony of the witness stricken from the record, because I felt like that was the only thing I could do when a witness admitted he had perjured himself on the stand. So there was a continued discussion about that particular issue, whether it should be struck or not, throughout the trial up to the very end. But I did not renew my motion for mistrial.
Thank you.
I do believe this was also invited error in the case. I think it's very clear the defendant wished to proceed. I think it's clear why. I don't think there was a fundamental failure in this proceeding, just as Justice Breyer's brought up. I mean, the whole point of having the whole point of cross-examination is for something like this to happen, hopefully, at least in the eyes of defense counsel. I also believe if it's found to be an error in this case and it's not found to be invited, that it was harmless in the face of the overwhelming evidence presented. And with that, unless the court has any questions, I'll stand on my brief with regards to the other issues. Thank you.
Thank you.
Ms. Tatum talked about the fact that Cox was early on in the trial. He was the seventh of approximately 40 witnesses the state called in this trial. And at the time he testified, obviously, the jury hadn't heard all of the other incriminating evidence that Ms. Tatum talked about that occurred later in trial. My argument would be contrary to what Ms. Tatum argued, that this needs to be looked at the point that Cox testified. The other testimony needs to be put aside because the decision about whether mistrial was appropriate had to be made in the context of what happened up to the time and through the time that Cox testified. And at the time that Cox testified, Ms. Tatum is saying that this wasn't a fundamental failure of the proceeding, but at the time Cox testified, Ms. Tatum was saying the state can't get a fair trial any longer after the jury's heard Cox's testimony. So the state apparently at that point was thinking that there had been a fundamental failure in the proceeding, and I think they were right. The main problem here, I think, is that the jury was allowed to consider perjured testimony in reaching a verdict. And I would argue that to say that what happened in this case is okay would be the equivalent of saying, well, the defendant in this case really wasn't entitled to a fair trial, or to say it's okay if the jury considers perjured testimony in reaching a verdict. And it's clear that the district court was of the opinion that the jury could not put this evidence aside and would use it in reaching a verdict in the case.
But they would use it to reach the verdict after all of the other evidence came in. So when you're talking about a fundamental failure, it has to be viewed at the time of the testimony. On the cause and effect, the effect would occur after all of the evidence when they deliberate.
I suppose that's true, but my point is we shouldn't have gone on to the rest of the evidence. The court didn't have any options at that point other than to declare a mistrial because all the requisites for declaring a mistrial were in place.
I'm sitting here trying to imagine if the court had granted the mistrial after you withdrew your motion, state moves for mistrial, it's granted, there's a second trial, that I think your position would be much stronger that the district court abused its discretion in granting the mistrial in the second trial because it took away your opportunity to discredit the state's case.
Capitalize on the success of
Yeah, I just think that's would have been your position, and I think it's Just
Well-
I know it's a different scenario. That's what you'd be arguing, and I think I'd be more inclined to your position if that were the case.
Well, sorry to hear that, I guess, but,
And I think that's what you'd be doing.
well, it's probably, I guess that's what I do. I argue the issues that I have. So thank you. I don't have any, unless the court has other questions.
Any further questions? Thank you, counsel.
Thank
Thank you both for your arguments this morning.